of endorsements from the Negotiable Instruments Act of 1881. Endorsement means signing at the back of the instrument for the purpose of negotiation. The act of signing a check for the purpose of transferring to someone else is called the endorsement of check. Section 15 of the Negotiable Instruments Act 1881 defines endorsement. The endorsement is usually made on the back of the check. If no space is left on the check, the endorsement may be made on a separate slip to be attached to the check. There are 6 kinds of endorsements. 1. Endorsement in blank, general. 2. Endorsement in full, special. 3. Conditional endorsement. 4. Restrictive endorsement. 5. Endorsement sans recourse. And 6. Facultative endorsement. Definition of endorsement. Endorsement when the maker or holder of a negotiable instrument signs the same, otherwise than as such maker, for the purpose of negotiation on the back or face thereof or on a slip of paper annexed thereto, or so signs for the same purpose a stamped paper intended to be completed as a negotiable instrument, he is said to endorse the same, and is called the endorser. Kinds of endorsement. Endorsement is of 2 kinds: endorsement in blank and an endorsement in full. According to Section 16 of the Negotiable Instrument Act 1881, if the endorser signs his name only, the endorsement is said to be in blank, and if he adds a direction to pay the amount mentioned in the instrument to, or to the order of a specified person, the endorsement is said to be in full, and the person so specified is called the endorsee of the instrument. A. Endorsement in blank, general. An endorsement is said to be blank or general when the endorser puts his signature only on the instrument and does not write the name of anyone to whom or to whose order the payment is to be made. B. Endorsement in full or special. An endorsement is special or in full if the endorser, in addition to his signature, also mentions the name of the person to whom or to whose order the payment is to be made. There is direction added by endorse to the person's specified, called the endorsee of the instrument, who now becomes its payee entitled to sue for the money due on the instrument. I'm going to read that one over. An endorsement is special or in full if the endorser, in addition to his signature, also mentions the name of the person to whom or to whose order the payment is to be made. There is direction added by endorse to the person specified, called the endorsee of the instrument, who now becomes its payee entitled to sue for the money due on the instrument. Conditional endorsement. The conditional endorsement is negotiation which takes effect on the happening of a stated event or not otherwise. Section 52 of the Negotiable Instruments Act 1881 provides the endorser of a negotiable instrument may, by express words in the endorsement, exclude his own liability thereon, or make such liability or the right of the endorsee to receive the amount due thereon depend upon the happening of a specified event, although such event may never happen. D. Restrictive endorsement. Restrictive endorsement seeks to put an end the principal characteristics of a negotiable instrument and seals it further negotiability. This may sound a little unusual, but the endorsee is very much within his rights if he so signs that its subsequent transfer is restricted. This prevents the risk of unauthorized person obtaining payment through fraud or forgery, and the drawer loses his money. E. Endorsement sans recourse. Sans recourse, which means without recourse or reference, as such, when the property, as such as when the property in a negotiable instrument is transferred sans recourse, the endorser negatives his liability and excludes himself from responsibility to all subsequent endorsees. It is one of the commonest form of qualified endorsement and virtually prohibits negotiation since the endorser says in effect. F is facultative endorsement. Facultative endorsement is an endorsement where the endorser waives some right to which he is entitled. For example, the endorsee is liable to give notice of dishonor to the endorser, and normally failure to give notice will absolve the endorser from his liability. Condon laureum versus the custodian evacui property Bombay Varuganti Sashareddy versus Vankata Sabayaya and Ors K.A. Padman Abahade versus K. Sabaya Seti is called a facultative endorsement. Facultative endorsement. And there was a reading from endorsement, kinds of endorsements from the Negotiable Instruments Act, 1881.